The next speaker on the subject is Professor Alexander Proelss. He is the chair in the International Law of the Sea and International Environmental Law, Public International Law and Public Law at the Faculty of Law of the University of Hamburg. Prior to that, he was teaching at Trier University. Professor Proelss also has been a member of several national and international research consortia and has advised various agencies. Today, he'll be speaking on the topic marine environmental protection in the EU, the example of discharges from ships. You have the floor, Professor Proelss.
Thank you so much for the kind words, Judge Chadha. And please allow me to start by sharing other colleagues to extend my gratitude for having received the invitation to speak at this conference. Yes, it would have been nicer to meet in person, but as we said before, we have to do the best out of the situation. And certainly a digital event is better than no event. Excellencies, colleagues, and friends, it is really a particular honor for me to participate in this panel together with Judge Chadha and my fellow colleagues, Professor Young and Professor Harrison, as well as the two commentators, Dr. Toy and Professor Ship. Now, I've decided to take a slightly different approach to the issue of this session, which is regional marine environmental protection, by looking at one specific activity, or rather one type of pollution, namely the example of discharges from ships. Yes, you may probably think that this is a subject which is quite technical, and it truly is. At the same time, the issue is characterized by a considerable degree of complexity, in particular also as far as the legal side is concerned. I'm bringing this up because I believe that discharge from ships is a striking example of what could be called the multi-level structure of the legal regime governing the protection of the marine environment as such, and that also includes the regional level of governance. And I think it is also representative for legal challenges and problems that may arise as the result of interaction between various different instruments on different levels of regulation. And that again includes the level of public international law, regional international law, but also from a European perspective, which I hope you allow me to take today from the perspective of European Union law, which is indeed a matter that has certain implications with regard to the issue which I'm going to address. Before delving into the details of one specific kind of discharges from ships, let me remind us all of the normative structure of the regime concerning the protection of the marine environment. Now, as was stated before, and as is well known, Part 12 of the Law of the Sea Convention establishes the legal framework, which is then further developed and specified by global agreements, which are again, at least sometimes, further developed by regional agreements. And this is exactly the level which this session is dedicated to. And again, all these criteria and requirements are then going to be implemented on the level of domestic law. Now, how does this look like with regard to my specific category of pollution, namely pollution from ships? The two central, even though certainly not the only applicable articles of the Constitution for the Oceans, the Law of the Sea Convention, are Articles 211 and 212 with regard to ship emissions. Now, these are further substantiated on the global level then by what is often called, even by the convention, as is well known, the generally accepted international rules and standards. This is the abbreviation which I'm using on the slide. And with regard to pollution from ships, the pertinent agreement is the MARPOL Convention, which again, by reference to its annexes, further distinguishes between different types of pollution from ships. As far as the regional level is concerned, there seems to be a gap here taking into account that shipping is one of the truly global transport modes, which again then necessarily depends on globally uniform rules. At the same time, as I will demonstrate in the minutes to come, there are indeed some regional rules in place which are relevant with regard to the issue of pollution from ships. From a European perspective, this is, for example, relevant with regard to the Helsinki Convention applicable to the Baltic Sea, but also with regard to European Union law. Now, EU law is often by the Court of Justice of the EU considered as an autonomous legal system, but it does, of course, interact with both international law as well as the domestic legal systems of the member states. What are the legal challenges then? Well, the first step, of course, is that the generally accepted international rules and standards need to comply with the general principles codified in Part 12 in the Framework Convention part. Then again, on the regional level, if I may focus on the European Union here, we have to keep in mind that the EU is a party to the Law of the Sea Convention, but it is not a party to the majority of IMO conventions, and that indeed includes MARPOL. Now, the question may then arise with regard to the member states of the EU, what happens if the EU legislation doesn't comply with the IMO conventions, in particular the MARPOL convention, to which, as I said before, it is not party to. So this may bring the member states into a difficult situation because the member states are bound to all of these international agreements as well as EU law. But what happens if these different subsystems of the law of the sea, or rather of the law concerning the pollution of the marine environment by ships, are not compatible with each other? And then let's not forget that there may be other agreements in place which may partly overlap concerning their territorial and substantive scopes with both the Law of the Sea Convention, the MARPOL Convention, and European Union law. And that obviously carries with it the risk of potential regime collisions. And I'm going to say a few more words on that in a couple of seconds. Now, due to time restraints, I will focus on one specific category of discharges from ships, namely scrubber wash water. And I sense that some of you will not heard of this category of discharge, so allow me to briefly introduce you to it. What we are talking about here is wash water. That is a product of washing machines, if I may use that word, that have been installed and are operated on seagoing vessels in order to comply with international emissions standards. Now, such scrubber systems are designed to remove pollutants from exhaust gas of ships. One category of these installations, referred to as wet scrubbers, brings the exhaust gases in contact with any kind of liquid. This could be seawater, fresh water, or some other substance. And the pollutants included in the exhaust gas are thereby washed out of the gas, thus producing wash water. And the question then arises what to do with this wash water. And indeed, one specific kind of these installations, called open loop scrubbers, partially discharges this wash water into the sea after the cleaning process. And that, of course, results in what is called a pollution of the marine environment under the definition that is codified in the Law of the Sea Convention. Now, the risks, the environmental risks involved in the operation of scrubbers are, of course, particularly relevant with regard to areas where there's a high concentration of such wash water and the pollutants included in it. And that is particularly true with regard to seaports and estuaries, meaning at least partly parts of the internal waters. Originally, scrubbers in general were considered as what could be called a transitional technology until clean marine fuels would be generally available. But as it has turned out, many ships use these installations in the meantime simply because it is more cost effective, in other words, cheaper, to install such machinery on board of the ships than to invest in clean marine fuels. And that brings with it problems concerning the protection of the marine environment with regard to ships. Now, what is the legal regime applicable to such scrubber wash water discharges? The first provision which I would like to refer to here is included in Part 12 of the Law of the Sea Convention, but is often kind of overlooked, and that is the prohibition of transformation of pollution under Article 195. I've copied the wording of that provision onto the slide, and as you can see from the highlighted section, this duty essentially prohibits the transformation of one type of pollution into another. And the question arises, is that just not happening in the context of operating scrubber machinery on board of ships? Yes, it is happening. We are talking about transformation processes here, but I would nonetheless argue that Article 195 does not establish an absolute prohibition of such transformation, but rather that parallel to the other provisions of Part 12 of the Law of the Sea Convention should be read in terms of an obligation to ensure. I'm arguing this based on the normative structure and content of Part 12, which seems to act on the assumption that absolute prohibitions are not foreseen, and potentially absolute prohibitions could even be contrary to the objectives. Just think of the situation that using a certain technology which is not 100% environmental friendly may still be much more environmental friendly than not using any kind of technology. And then, of course, a reference should be made here to the practice of the IMO, the International Maritime Organization, as the competent international organization with regard to pollution from ships. And as I will show you in a minute, the IMO has indeed established and adopted regulations concerning the deployment of scrubbers, indicating that the IMO, as the responsible organization, doesn't consider such deployment as a violation of the prohibition of transformation. All that said, in light of the precautionary approach, which I would join fellow colleagues to read into Part 12 of the Law of the Sea Convention, any kind of transformation ought to be based on the best scientific knowledge available, requires monitoring, and it should generally be limited to transitional periods. Let me then move on to the generally accepted international rules and standards established by the IMO, and reference has to be made here in particular to Annex 6 of the MARPOL Convention. Now, this Annex 6 affects ship emissions, at least predominantly. It aims at reducing pollution by ship exhaust gas at the source by limiting the pollutants in the ship fuels. At the same time, it does contain a regulation, that is regulation number 4, the wording of which you can see on the slide, which allows for the use of what is called alternative methods in order to achieve the objectives of Annex 6. And the argument is made that scrubbers are indeed to be considered as constituting such alternative methods. Indeed, the regulation contained in Annex 6 makes reference to the alternative methods, but puts their deployment at the discretion of the contracting parties by using the vocabulary may allow. The regulation to which I just referred is then further substantiated by a set of guidelines, which has been amended several times, the most recent version being the 2015 IMO guidelines for exhaust gas cleaning systems. Now, and here we have a document which specifically refers to the deployment of scrubbers. These guidelines are not per se a binding legal document, but they have become indirectly binding by way of the obligation to take them into account, which is indeed included in Regulation 4 of Annex 6 to the MARPOL Convention. Now, these guidelines again include specific requirements concerning wash water, which you can see on the slide, which contain, for example, the obligation to monitor and record, and secondly, establish certain limits. This now is really technical, so I'm not going to go into the details of this, but rather just remind you of the fact that there are indeed certain limit values which must be observed under these guidelines. Let me move on then to the regional rules and start by European Union law, which may be somewhat foreign to many of you, but I'm trying to keep that as understandable as possible. Notwithstanding the fact that the EU is not a party to the Marpol Convention, it has implemented Annex 6 of that convention on the level of the EU by adopting what is called the Sulfur Directive. Now, what is interesting is that the EU has gone beyond the Marpol Convention by establishing a binding legal obligation. There is no discretion anymore of the member states to permit in their domestic legislation the use of emission reduction methods such as scrubbers. So there has been a strengthening of the international minimum standards contained in the Marpol, potentially to the disadvantage of the marine environment. But this is not the only legal act that ought to be observed on the level of EU law. Rather, others also have to be taken into account. Without going into the details here, particularly relevant is the Water Framework Directive, which is indeed applicable to some parts of the marine environment located nearby the coasts. And this directive includes a prohibition of deterioration, which has to be observed with regard to the objective to achieve what is called a good surface water status. In other words, what needs to be done is that the Sulfur Directive must be interpreted and applied in such a manner that it is in compliance with the requirements of the Water Framework Directive. The newly established Port Reception Facilities Directive now expressly refers to scrubber, washwater, and sludge. And what is interesting is, last bullet point on the slide, that it encourages the member states to take appropriate measures, and I quote, in accordance with the Water Framework Directive, including discharge bans for wastewater from open loop scrubbers, end quote. And this is obviously somewhat in contradiction to the fact that the very same European Union has made it mandatory for the member states to allow for the use of scrubber systems, provided that the conditions of the regulation are given. I referred to this before. There may also be other regional agreements that have a word to say with regard to a certain category of pollution. And indeed, within Europe, there is a specific convention applicable mainly to freshwater ecosystems. However, this convention overlaps partly with Marpol, as well as the EU instruments to which I referred before, because it is applicable also to parts of the internal waters of the EU member states. And the problem is that this very convention now contains an absolute prohibition of any kind of discharge from ships that result from the operation of including seagoing vessels. Now, how does that all fit together? We clearly have what I would call a regime collision, specifically arising in the context of the regional regime for the protection of the marine environment. Without going into any detail, I believe that this conflict within Europe can only be solved on the basis of the principle of primacy of EU law, which then means that the regional convention to which I just referred before cannot be applied to the parts of the internal waters where there is an overlap of instruments. This leads me to my conclusions, just only 2 more slides. Now, the first thing within the very brief amount of time allocated to all speakers, what I've tried to highlight is that the issue of discharges from ships can indeed be seen as a typical example of multi-level governance. Global standards adopted within the IMO, which substantiate the law of the Sea Convention, and which usually only establish minimum standards, are then further specified on the regional and within the EU on the supranational level before being implemented on the domestic level. Now, generally speaking, the EU as an actor on the field of the law of the sea has just taken the role of what I would call an implementer, taking into account also that it has not and could not become a party to the Marpol Convention, which is only open to states. However, it has established on its own level of regulation a legal regime which is in itself somewhat contradictory, which indeed subjects the member states to potentially conflicting obligations. And what results from this is the manifest danger that is just a prototypical consequence of the phenomenon of fragmentation, with regard to which Professor Young has published a widely cited book. Just as kind of an outlook, in order to finish and wrap up, particular problems arise when the EU as a regional actor decides to depart from the globally applicable standards through supranational legislation. For example, in order to exert political pressure for the adoption of more stringent global measures. And indeed, this has happened in the past, and the law of the sea related example is, or one of them at least, is the phasing out of single oil tankers. Now, this may be welcome from the perspective of environmental protection, but it gives rise to significant legal problems. And this may come up in the future again, taking into account that the Parliament of the European Union has indeed proposed to include global international shipping into the EU emissions trading system. So what we may see here in the future is a revised version of the disputes that have arisen with regards to international aviation. And with that, I would like to thank you so much for your kind attention. Once again, thanks for the invitation.
Thank you very much, Professor Proelss, for this very informative presentation on legal requirements concerning discharges from ships. You have also highlighted the challenges that may arise from multi-level governance when regulation of discharges from ships are covered by global standards adopted within IMO, as well as which may be altered within the Europe through a more stringent supranational legislation or existence of separate regional agreements. So I think this was a very good presentation, making us all aware of the technical requirements within the maritime law, which most of us who are dealing with law of the sea issues alone sometimes are not aware. Thank you very much.